lecture for late ad students or students who just want another opportunity to talk about how to brief a case. The idea of briefing a case is so that you can take a court's previous opinions, from that opinion in that previous case, figure out a rule that you then can apply to a future case that you want to either analyze or argue for an intended result. Your project paper this semester is going to be an argument brief, where you're going to have to make an argument to a court to convince the court to decide in your favor. And the reasoning in your argument will be that the court has to act consistently with its prior opinions. And the way to do that is to take the prior opinions, find from those opinions the rule that the court applied in that previous opinion, and apply that rule to your case in such a way that it ends up giving you a favorable result. And so this briefing process is how we get the rule out of that case. So we're going to take a very popular case, a case that's known to, I think, every law student, the case of Palsgraf versus Long Island Railroad. It's an old case, and it is a case that defines the term proximate cause in negligence. So tell you what happened in the case, and then we'll go through the briefing process after that. So in this case, a Ms. Palsgraf was waiting for a train on at the train station, and a different train was there, and there were two men who were trying to get on the train as it was leaving. The first man jumped on the train as it was starting to pull out, and there was no problem. The second man was struggling a little bit, and a train employee from inside the train reached out to help him, and a steward on the train at the train station gave him a push to help him get up into the train. As he gave him a push to get him into the train, the passenger dropped a package. It was just not an oversized package. It says about 15 inches long, wrapped in newspaper. Package falls out of his arms, drops below the platform and onto the track. The train hits it, and it explodes. It was full of fireworks. The explosion caused a shockwave that went to the other end of the platform where Mrs. Palsgraf was standing next to a set of scales. The scales fell over, injuring Mrs. Palsgraf. She sued the railroad company for the porter's negligence. And the question came down to, was the act of pushing the person, helping a person onto the train, negligence as it related to Mrs. Palsgraf at the other end of the station? That's the question that we're going to have to decide in this case, or that the court had to decide. And so then we can take how the court decided this case, and we can apply that rule of what's called proximate cause to future negligence cases. So the first thing we do in a brief is we'll have a brief recitation of the facts. The purpose of this is so that, mainly so that we can show that the facts of our case are in some way analogous or similar to the facts of this previous case. So as we're going to argue our case in the future, we want to show similarities. And so we want enough facts there so that we can see what kind of a case it was. Secondly, it just frames the argument. The law is not an abstract thing. It needs that context of something actually happening to someone. And so the facts helps to frame that context. So that's the first thing, are the facts. What we want here are all of the facts that are relevant to the discussion. Whatever facts we're going to rely on later on in our application, we want to have included in here plus enough just to kind of fill out the story for the reader. And as a student, it also helps you to remember the case. If you're like me, the names just kind of all turn into a blur. All the case names are the same. But if you say, oh, it's the woman at the platform at the train station, you'll remember that case. So it's another reason for the facts there is just enough to trigger it for your memory. So we would list here just the basic facts. Mrs. Palsgraf was at the train station. There was a man running for the train with a harmless looking package. As he was being assisted and pushed onto the train, the attendant knocked the package out of his arms. It exploded. The explosion caused an injury to Mrs. Palsgraf some distance away. That would be all you would need for the facts. The second part is the issue. The issue is the legal question that the court answered in this case. So the issue is always a question of law. So in this case, what the court was having to answer was whether the conduct by the railroad employee as it related to the other passenger could be the basis for negligence as it related to Mrs. Palsgraf, who was some distance away. So could his conduct with this other passenger be sufficient cause for a negligence claim to Mrs. Palsgraf? So you see how this is not a factual question. We can research all the facts we want, and we couldn't answer that question. That question can only be answered by applying a law. And so that's why we talk about it as a question of law. If it's something you could look up or get evidence for and answer the question, then that becomes a question of fact, and that's not what we're interested in. So the question of law is whether that conduct far away could lead to a negligence suit for Mrs. Palsgraf. The third part is the rule. The rule, when you're doing a summary brief like this, is the most important part of the brief. This is the part of this brief that you're actually going to take out of this brief and apply it to your case. And so it ends up being this whole purpose for this case is this rule. In this case of Palsgraf, the court defined what we call approximate cause. As you remember when we talked about negligence, you have to have two types of cause that you show for a negligence suit. Cause and fact, which creates this large area of potential liability, and then proximate cause, which then limits that based on some rule of reasonableness, which is what we're going to talk about. What Justice Cardozo said in this case was that in order for there to be liability, the person who's committing the act, who is arguably breaching a duty, must have reason to know that a harm will occur and the extent of that harm. Proximate really is a geographic term. It talks about location, whether something is nearby, but that's not its only meaning in this context. It really means foreseeability, whether that person could foresee the consequences of his actions. If we were to change the facts, it will illustrate it a little bit. If the passenger had a package that was bright red and said, "Warning, explosives," do you think the porter would have unceremoniously tried to shove him onto the train? Probably not. You see, he probably would have been more careful. But because the package was just a plain, ordinary wrapped package, people getting on a train, you would think they have, you know, their luggage, their clothes, toiletries, maybe if it's a business person, their business things, papers, those kinds of things. You don't think explosives first. And because an ordinary person in the porter's situation would not have thought of explosives, he's not going to be held to that standard, because it's not foreseeable that if he knocked that package out of his arms, it would cause an explosion. It's also not foreseeable, if you're pushing one person onto a train, that somehow might cause a harm to a person who's standing a long distance away at the other end of the station. And so because he couldn't foresee this act, or this harm from his act, he's not going to be held liable for it. And that's the rule of proximate cause. The rule is that the defendant will only be liable for the harms that were foreseeable at the time of the act. So in this case, if he's carelessly pushing the man onto the train, his harms could be injury to that man, if the man was to fall, injury to himself, harm to the train potentially, the damage to his package, whatever it is he's carrying. But it's not foreseeable that he would cause this other harm. So the rule then is this rule of foreseeability. The next part is the application. So in the rule, when you write it, and I've just been talking and we get a little sloppy and lazy while we talk, but when you're writing, you only want to have the rule of law here in the rule statement. You do not want any discussion about your own case there. So if I were writing the rule, what I would say is that in order for a defendant to be liable for negligence, the harms that are caused must have been the type of harm that would be foreseeable at the time of the conduct. That rule has its own existence. It is a rule of law. It doesn't rely on your case to be true. So we don't mention your case in there. Now we're going to apply that rule. And so that's where we take the facts that we had written, compare them to the rule, and show that comparison. So we would then talk in the application section about the porter helping the person onto the train, his foreseeable damages that could be caused would be those to that passenger and his package. But there was nothing there that would indicate any harms that would go beyond that. My suggestion is also this: after you write the application, read the application and reread your facts, and be sure that any facts that you mention in the application, you also put in the facts section. So don't bring up new facts in the application. If you need new facts, go back up there and write those. So go back and review that facts section afterwards. After you've done your application, the last step is the conclusion. The conclusion is just simply the answer to the question. It's not any more discussion, it's not any more argument, no more application, it's simply the conclusion. So if the question is a railroad employee pushing a man on a train, liable for injuries caused by an explosion to a person at the other end of the platform. Conclusion is no. The harm was too remote to be foreseeable. It's just an answer. If you have some other really good argument to add, don't add it in the conclusion. It needs to go up into the application section. That's not as hard to do when it's a summary brief like this. But when you're writing your argument brief for the project paper, it'll be hard not to do that. You'll get to the end and you'll want to make your argument again. You want to be sure that it really gets in there. And you say, well, I want to be really persuasive. I'm going to say my best argument till last, and I'm going to put it in the conclusion. It's the wrong place for it. Get all the argument up in the application or argument section, okay? Your argument brief will follow this same pattern. The difference will be that your facts will be whatever facts led to the particular case. The issue will be whatever the issue is that the Supreme Court has agreed to resolve. And you'll be given the issue for your project paper. The Supreme Court says what question they will answer. The rule will be a variety of things. It will not be one thing. In your argument, you're going to have several different parts to the rule. You're going to have maybe a constitutional provision. You're going to have possibly statutes, maybe administrative rules, regulations, and you will certainly have cases, prior cases. So what happens in that brief is that your summary briefs of those prior cases will become the rule section of your argument brief. Your summary briefs will define this rule that you want to have the court apply. But again, in that argument brief, you still will not discuss your case in the rule section. You only will discuss prior cases and the court's prior rulings. Then, in the argument brief, we don't have an application section, we have an argument section. This is where you will make your argument based on the rule that you believe applies. Any questions on briefing a case?
So far, so good.
So far, so good? Okay. All right. One thing that students ask me is how long should a brief be? That's a question I get a lot. The brief should be long enough to adequately summarize the case so that the reader can understand the case without going back and reading the whole thing, but not so long that it becomes confusing. They tend to end up a page and a half to 2 pages is kind of a typical length for a brief, depending on the complexity of the case. In this case, Paul's graph, because it was a single issue and it was pretty well defined as an issue, the brief could probably would almost certainly be less than a page. Okay? Well, thanks for coming. I hope it was helpful. For those of you watching online, if you have questions, send me an email. Thanks.